Good morning, sir. You're Patrick Gallagher. And Mr. Gallagher was previously in court, entered a plea of guilty to driving while intoxicated, third or more. And I received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, Your Honor, yeah.
Are there any additions or corrections?
No, no mention.
I didn't see any, Your Honor.
So, Mr. Gallagher, you want to know what my big concern is? How long were you off probation for your DWI second when you got your DWI third?
I can't remember.
4 days.
4 days.
Mm-hmm. That's what it looks like to me. It expired. Community supervision expired, looks like October 3rd of 2024 is the way this reads. New case, October 7th of 2024. What, if anything, have you done with regard to any kind of drug treatment? Anything on your own to stop using alcohol or drugs?
I quit drinking. I pray to the good Lord because I'm a single dad with grandkids, so that's over with.
Well, it should have been over with when you were on probation last time.
Yes, ma'am, I agree.
And I appreciate that you're praying, but sometimes that's not enough.
I agree with that too.
Are you still working
Yes, ma'am.
at Exxon?
Yes, ma'am.
Judge, there is one issue I need to bring up whenever you're done speaking.
Go ahead.
I'd spoken to the prosecutor about this. He is a full-time shift worker, and one of the issues was he had brought in his work schedule as the court was willing to, he had dates that he was not working to do the 10 days.
At around this point in the hearing, the judge shifts focus and begins addressing the defendant directly with a firm and controlled tone, making it clear that time and patience are running thin and expectations are now non-negotiable. The court points out that earlier opportunities were not handled with urgency, even though there were moments where effort was shown, and the judge acknowledges that while the request made to the court was significant, it still carries weight and responsibility. The discussion moves towards scheduling concerns, and the judge explains that work commitments will not serve as an excuse moving forward, and that adjustments must be made regardless of inconvenience. The key condition is then delivered with clarity, stating that the defendant must enroll in and fully complete the JCDI program, which is described as an intensive outpatient requirement that demands strict consistency and discipline. The judge emphasizes that others have managed similar schedules and expects the same level of commitment here, with no room for error or delay. The warning becomes direct and serious, as the court explains that any failure to comply will result in an immediate return to custody and could lead to a prison sentence, making the consequences clear and unavoidable. The moment ends with the judge seeking confirmation that the defendant understands the gravity of what has just been ordered before preparing to move forward with the next step in the proceedings.
Your plea of guilty freely and voluntarily. Have you been wearing a drug patch either, or no? Was that a condition of anything? I didn't.
No, Judge. It
The
wasn't.
bond, it wasn't a condition. Well, because the blood came back with positive of Delta 8 THC. I'm sorry.
That's correct.
Yeah. Are you doing anything like that still?
No, ma'am. I work for ExxonMobil.
Well, I mean, did you work for them when you...
I did, but I had a vape that I didn't know was there, so that's history.
You're 52 years old, and you're using a vape that you don't know what's in it. Do you want me to buy that?
You don't have to, no, ma'am.
I don't. Because if you don't know, then you should have known. So either way, it's ridiculous that, I mean, that's something that a teenager would come in and tell me, I got a vape and I don't know what's in it. All right, I'm going to do this. Going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time follow your agreement. Find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement. Well, actually, I'm not going to follow the agreement with regard to the length of time on probation. The fact that he was just off of probation, I think, warrants longer than a 5-year probation. The length of your probation period is ultimately up to me anyway, so it's not like I'm following the main part of the deal, but you still wouldn't have a right to appeal because that's up to me. So I'm going to find you guilty, sentence you to 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that and place you on probation for 7 years. You're ordered to follow all of the rules and conditions of probation. That's going to include entering and successfully completing the JCDI program and following, obviously, all of the rules and conditions. You'll have an auto ignition interlock device on your vehicle. Do you already have that? You're going to keep that at least for some amount of time. And if he has the interlock, you can make a notation. I don't need interlock and scram and portable, whatever they feel like is best through JCDI. Once that gets going, I'm fine with. I am going to order that you serve the 10 days upfront time.
The court then turns to the schedule and lays out the custody timeline in clear terms, stating that the defendant will report on the 17th and remain until release on the 19th, making that short period part of the required time to be served. The judge reviews the work calendar and presses for clarity, explaining that if no shift is listed, it will be treated as time off and therefore available for compliance with the court order. The discussion acknowledges staffing shortages and prior overtime sacrifices, but the court makes it clear that these factors will not change the obligation to complete the required days. The judge then maps out the next phase, stating that in October, the defendant will use a longer break to complete a full week by reporting on the 16th and remaining until the 23rd, which accounts for 7 consecutive days.
And get out on the 19th. If you don't have something written, days or nights, does that mean you're off?
We're so short-handed, it's a possibility, or I had to work overtime because I gave up 2 days overtime already for the 11th and 17th.
Okay. If it doesn't say days or nights on this calendar, does it mean you're off?
Yes, ma'am.
Okay. So that second one in October, you're going to go, we're going to get this done. Because that's your long days off. So we're going to get that week all done. So you're going to go in on the 16th, and you're going to get out on the 23rd. So that gives you 1 overnight, 16th, 17th, 18th. That gives you 7 days. And then that first one only gives you 2 days. So that's 9.
So are you saying go in on the 16th when I get off work that day?
Mm-hmm.
Okay.
And we're just missing 1 day.
There's 7 November on the back of it there.
No, we're getting this will be done in December. So you're going to then go in on the 28th
Yes, ma'am.
at 6 p.m. and you'll get out the next day, and I'll take care of that last day. So, and then Anna will probably need that too. Make sure you get all of those done. Okay. All right. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you.
The judge continues by explaining that the term firearm has a specific legal meaning and directs the defendant to carefully review the written notice provided so he fully understands which items fall under that definition and what restrictions apply. The court adds that if there are any doubts about eligibility to possess a firearm or ammunition, or about how long the restriction remains in effect, those questions should be discussed with Mr. Rennick to avoid any confusion or future violations. The defendant is then instructed to remain seated in the courtroom and wait until probation staff calls him forward to review and complete all required paperwork before leaving. The judge offers a brief closing remark, wishing him well as the process moves forward, and then transitions to the next matter by calling the name of Mr. Boyd and confirming his identity for the record. The court begins addressing Mr. Boyd in the listed case number and prepares to proceed with the next hearing while maintaining order and continuity in the courtroom.
25 DCCR 0720, you're charged with a third-degree felony offense of deadly conduct, discharging a firearm from March 20th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 10 years in prison. Do you understand?
Yes, Your Honor.
And I'm going to get a plea bargain rejection. What is the offer?
The state's offering 10 years, probated for 10 years with a $2,500 fine. Standard conditions and no contact with a couple of complainants, as well as stay away from the Little Woodrow's establishment.
Sir,
There.
spit whatever is in your mouth out in that trash can over there. So you've signed a plea bargain rejection with your attorney, Mr. Jeffries, and it's going to show 10 over 10, right?
That's right, Judge.
So it's for, if you wanted to enter a plea of guilty for a 10-year term in prison, that would be probated. You'd be on probation for 10 years. You would be ordered to pay a $2,500 fine to follow all of the rules and conditions of probation. You have every right to reject that and have your case set for trial. I want to make sure you understand today what your options are if you wanted to plead guilty and what your possible consequences are if you go to trial and are found guilty. Do you understand all of that?
Yes, Your Honor.
And do you want to reject that offer and have your case set for trial?
Yes, Your Honor.
All right, we'll get it set for trial. Mr. Coleman, is there any reason to believe that that offer would change?
Not at all, Judge.
So, Mr. Boyd, I want to make sure you understand that after today, I don't accept plea agreements once they're rejected. So unless new information comes to light with your attorney or the district attorney's office, then if you change your mind later and want to enter a plea of guilty, it would be to something different than this or open to the court. Do you understand?
Yes, Your Honor.